the commission is effectively changing the scope of the regulation without asking Congress to pass a law and without going through the usual process by which agencies can issue regulations. The commission could issue a regulation that directly cover the products that Jake's is selling, but it hasn't done that. So instead, it issues these notices and anticipates that many companies don't have the wherewithal to fight back. And so it becomes regulation through adjudication, and really not even through adjudication, because all they have to do is send these notices out, hope that companies don't respond, and then next time they can say, look, we've sent this notice out to other companies, the other companies have complied, and this is now our official understanding, while at the same time preventing companies like Jake's from even challenging that determination. It's completely unfair.
Americans are capable of achieving extraordinary things when they have the freedom and opportunity to do so. This is American Potential.
Hi, everyone. My name is David Fromm, and I'm the new host of the American Potential podcast. Today on the podcast, we're going to talk about a family business that was told to stop selling their products, in this case, fireworks, by the Consumer Product Safety Commission. This commission was established in 1972, and it states on their website that the commission, quote, works to save lives and keep families safe by reducing the unreasonable risk of injuries and deaths associated with consumer products. So, if their job is to reduce the unreasonable risk of injuries or death, why are they standing in the way of this family-operated fireworks business from selling their products due to the noise that it makes? Now, Jake's Fireworks was established in 1940, when the family started selling fireworks out of the back of their home. Since those humble beginnings, they have now grown to have stores in 9 states, as well as being a wholesale provider. Back in 2014, Jake started receiving letters from the Consumer Product Safety Commission saying that some of the fireworks didn't make the right noise, and if they sold them, they would be fined, which caused the family to not be able to sell over $2 million worth of inventory. The family took them to court, but there's a twist to the story. And I want to welcome today's guest, Oliver Dunford, who is the senior attorney for the Pacific Legal Foundation and is representing the family in this case. Oliver, welcome.
Thanks so much for having me. I appreciate it.
Just to start out, I'm familiar with the Pacific Legal Foundation, but I don't know, maybe you could help everyone understand the great work that you guys do all across the country.
Yeah, thank you. We were founded in 1973, originally in Sacramento, California. Since then, we have grown nationally, and we now represent individuals and small businesses across the country, fighting things like overregulation by government agencies, economic liberty cases, and equal protection cases. And we do all this free of charge thanks to our very generous donors.
Yeah, I've run across you guys a number of times, and you've partnered with our organization and other allies to truly defend freedom and in the courts and representing folks, I know from watching you, representing folks that really have no other recourse. So I think it's really the Lord's work you guys are doing, and certainly appreciate it. And wanted to get into, how that applies here. So the Consumer Commission said that the fireworks would make a pop noise, but not a bang noise, which seems kind of silly to me. So what makes the commission concerned about the difference between these two sounds?
Well, there's a decent backstory that gives them, a kernel of authority here. Originally, the fireworks were regulated by the FDA, and the FDA adopted a regulation back in the early 70s to prevent non-professional use of what were used by farmers mostly to scare pests away. They were handheld devices, and they made a very loud noise called a report. But some consumers got their hands on it, and some children were hurt, and so the FDA decided to ban commercial use of it or consumer use of it. But the fireworks that Jake's now imports are not subject to that regulation, and in fact, once the Consumer Product Safety Commission took over fireworks regulations, it has considered the question a few times, and it has publicly stated in its own regulatory documents that the consumer fireworks that Jake's sells, and these are just basic backyard fireworks that people can buy and set off on the 4th of July, that these kinds of fireworks are not subject to the regulation that the FDA adopted. Now, the reason that the sound comes into it is because the commission decided at some point that fireworks like Jake's should be subject to this regulation. This regulation is called the Audible Effects Regulation. And what the agency means by that is that if there's a firework that is intended to have an audible effect, then it's subject to the regulation. And again, the original fireworks that were subject to this regulation were made so that they would intentionally have a loud noise to scare pests away. And so now, as you referenced before, the commission is trying to fit all fireworks, or at least new fireworks, under this regulation. And so what they do is the commission has the right to inspect products at ports when companies like Jake's are importing products. And a staff member from the commission, we're not exactly sure, but it could be one individual, launches a firework in the air, and we don't know under what conditions. Could be raining, could be sunny, could be up against a wall, we don't know, and listens for a poof or a bang. If the staff member hears a poof, then he determines that the firework is not intended to have an audible effect. But if he hears a bang, then he determines that it is subject to this regulation. And therefore, if it has at that point, if it has a certain amount of pyrotechnic blast power, then it's banned under the regulation. But the initial test is simply a poof-bang test. It's also called an ear test. And so with that regulation and with that test, as you mentioned, the commission sent a number of notices of noncompliance to Jake's.
I'm kind of curious, as this moves its way through the courts, what does that sound like, so to speak, in like the actual trial? I mean, is there a long, drawn out process to figure out what's a poof and what's a bang? Are there expert witnesses you can call?
We don't know yet. And the fact is, there haven't been many cases. In fact, we're aware of one case that was over a decade ago. And that was the first time that the commission even mentioned that there had been a poof-bang test, or that this is how they determined whether certain fireworks were subject to that regulation. The test itself has never been adopted by the commission in any kind of official regulatory document. It just created this test without telling anybody, and then applies it. And I don't know, to answer your question, if we get to court, how we could prove or not prove that the fireworks are subject to the regulation.
So going back to the idea of this pest control device. So if I recall what you'd said correctly, the device at some point it was being used by farmers, and some maybe kids were injured trying to use it. That's where some more of the regulation came from.
That's right.
Yeah. And then how did they determine which fireworks fell under that regulation?
Yeah, the regulation talks about the noise, and I don't know exactly, now that you're asking me, the specifics of the language in the regulation, but the point was to prevent kids and non-professionals. So farmers are still allowed to use them. The problem was they're handheld, unlike other devices, which you put in a tube and launch them into the air. And so that was the safety concern, and especially because kids were getting their hands on them, and they were more powerful to make that noise at ground level. They were particularly powerful devices.
Yeah. So basically, they've said that the sound there's a correlation between the sound and how powerful they are. So that's why they are using that as an indicator of the power of some sort. That's
right. They've said that the commission has said that the sound is a proxy to determine how much explosive power a device has. But the commission has never determined that sound alone is a cause for concern, or is a danger or a risk of any kind. And so, again, as you just said, it's a proxy to determine, or supposedly to determine, the explosive power of devices.
Yeah, it would seem to me that there should be a more official way to figure out whether this is really dangerous to kids and regular people or not. The sound kind of seems like a poor substitute. But that's just my opinion.
No, that's right. And it's hard, like many things that agencies do, it makes it hard for companies to know in advance what is and what is not allowed.
Yeah, and it would seem like in this case, in particular, and a lot of others, that the uncertainty that government creates and like kind of the arbitrariness is really what makes it so hard for folks trying to earn a living, trying to build a business to keep doing that, because when something's arbitrary, you can't depend, and you really want certainty when you're building a business.
Yeah, that's right. And the fireworks are tested by a third party that the commission approves of before they are shipped, and these satisfied those tests. And the notices that are in question, some of them mentioned other potential problems with the fireworks, and Jake's didn't contest those because those are objective. And they do apply to Jake's products. But what Jake's objects to is not only the arbitrariness of the test, but Jake's contends that the regulation doesn't apply to their products at all.
Mm. So what did the commission say about that, about it not applying to them?
Yeah, went through the series of notices. Jake's responded in writing, in phone calls, and the commission, through its compliance office, kept saying, no, we believe that your fireworks are subject to this regulation. Here are the tests we did. And they gave some numbers. And Jake's not only challenged some of the numbers, some of the tests, but they said this regulation just does not apply, but the commission refused to reconsider.
And so the practical effect for Jake's, a family-owned business, is that they have $2 million worth of inventory that they've paid to bring in and import in, but they can't get any return on, right? I mean,
yeah, that's right.
That's how it's affecting their business.
Yeah, they're stuck. They have $2+ million worth of fireworks in warehouses, and can't sell them.
Yeah, that's rough for any business. But I mean, man, for family-owned business, I'm sure they're not like a massive enterprise.
That's right.
I'm glad that you guys are there fighting for them. So, because you guys have been going round and round with the commission, Jake's eventually took them to court. So what's happened in court thus far?
Yeah, and we did not represent them at this time, but they sued the Consumer Product Safety Commission in federal court. And as I mentioned, they challenged both the results of the tests, but primarily they said this regulation doesn't apply. But the court said that the agency had reached a final decision. And under the Administrative Procedure Act, companies or individuals are not allowed to sue an agency until the agency has reached a final decision. And that makes some sense. You don't want the agencies to be in court all the time defending absolutely any statement they make or anything that somebody may have a gripe about. But the Supreme Court has said that the court should apply a pragmatic test. The presumption should be in favor of a court's review of an agency action. And so, unfortunately, though, the courts below said that this was an action merely by the commission's compliance office, and that the commission itself had not decided to sue Jake's. But of course, the problems with that are, one, that the commission's enforcement office, the compliance office, is and are the agents for the commission to do enforcement. There's no other way it does it. The 5 commissioners themselves aren't going to the ports and testing these products. So the commission has to act through agents. And that's what it did here. And secondly, the fact that the commission has not yet sued Jake's doesn't mean that the commission hasn't made a decision. Indeed, through these notices and through communications and back and forth with Jake's, the commission has never backed down, has never changed its determination that the regulation does apply to Jake's. And therefore, we think that that's a final agency action. The commission has made a legal determination. There's no opportunity for Jake's to appeal that decision within the commission itself. So the only thing Jake's can do is either sue in court or sell the products and then risk a lawsuit by the commission. And the commission, in that case, could argue that Jake's should be, or that the commission should be able to impose heightened penalties because of the notices. So the commission, on the one hand, the commission says these notices aren't final. You don't have to rely on them. On the other hand, if they sued us for selling the products, they could point to the notices and say, Jake's, you had notice of the violation, and therefore we're going to hit you with heightened penalties, which can include criminal penalties, millions of dollars and up to 5 years in jail.
Wow. It seems like they're getting all of the enforcement and none of the due process.
That's right.
Unless they decide to go and sue.
That's right. And Jake's can do nothing. They have to sit and wait, or again, risk the enforcement action if they sell. And in fact, the commission made that in one of its briefs to the courts. It said if Jake's feels so confident about its position, it can sell the products and basically see what we do, which is not what the Supreme Court requires.
It just seems unbalanced to me. Someone who's this is the first time I've really kind of heard in depth about this case, and it just seems unbalanced. I know you're a lawyer and you deal in facts, but doesn't it seem like this isn't the way our government should be working when it comes to its people and the businesses that they're creating?
Yeah, there's no question. It's a as you say, it's an unfair way to issue regulations. The commission is effectively changing the scope of the regulation without asking Congress to pass a law and without going through the usual process by which agencies can issue regulations. The commission could issue a regulation that directly cover the products that Jake's is selling, but it hasn't done that. So instead, it issues these notices and anticipates that many companies don't have the wherewithal to fight back. And so it becomes regulation through adjudication, and really not even through adjudication, because all they have to do is send these notices out, hope that companies don't respond. And then next time they can say, look, we've sent this notice out to other companies. The other companies have complied, and this is now our official understanding, while at the same time preventing companies like Jake's from even challenging that determination. It's completely unfair.
It seems to me that they're kind of skirting around their responsibility as an agency. I mean, we can argue about whether or not they have overreach from an administrative standpoint, just the commission in general. But in this case, it's almost like they're taking it further. They're not making a final decision as a commission, and yet the enforcement arm and the compliance arm is acting punitively and causing Jake's to take all the risk. Is that something we see in other areas, or and what's the motivation here?
Yeah, we do see it in other areas. And in fact, PLF had a case a number of years ago called Sackett versus EPA. My colleague Damian Schiff litigated that to the Supreme Court. And that case involved some property owners who owned a small lot in a residential neighborhood with houses all over the place. It was near a lake. And the Army Corps of Engineers and the EPA said that this property was a wetland because there was some water on it at some point, and that it went through a drain and a ditch, or I forget exactly how, and ended up reaching the lake, and therefore the property was a navigable water subject to federal regulation.
That one pops up a lot, unfortunately.
Yeah, and the property owners asked for a hearing. The agencies denied it, and so the Sacketts sued. And they eventually got to the Supreme Court, and the Supreme Court said unanimously that the agencies could not issue this kind of order without giving them a hearing. And the EPA made the same arguments that the commission is making here, that it may have reached somewhat of a decision, but it hadn't decided yet to sue. And the Supreme Court said the EPA had made a decision on the law, and whether it feels strongly enough about that decision is a different, separate subject. And so we've made the same arguments. Look, the commission here has made a final decision about what the law says. That regulation applies to Jake's products. Whether it feels strongly enough about that decision to sue Jake's is a separate question. And so this is consistent across administrative agencies. They like to issue demands and couch them very carefully in language, saying things like, we request that you do such and such, please respond. And then when a company challenges and brings facts and law the way Jake's did, the agency will say, well, we haven't made a final decision yet, and we'll let you know if and when we do.
And all the while, the hammer is kind of hanging out there because Jake's is the one that's at risk.
Exactly. And
for financial and criminal penalties.
Exactly. And a later Supreme Court case, Hawks, which was also a PLF case, the court said that that regulated parties shouldn't have to wait for the hammer to drop before they're allowed to challenge agency decisions.
Do you anticipate the commission moving towards a final action? Do they have any incentive to do it?
No, they have none. None at all. Jake's has filed twice. I mentioned before the court dismissed it for lack of a final agency action. Jake's went back and talked a little more with the agency. The first trial court said that you could request an informal hearing. So Jake's went back and requested an informal hearing, asked the commission, is there anything else we need to do to make this final? And of course, the commission was noncommittal. So Jake sued again. The district court again dismissed it, and that's PLF got involved then, appealed the case to the Federal Court of Appeals, and reached the same decision. And particularly wrong with the circuit court's opinion was that it said that the notices that the commission issued didn't trigger any of the adjudication processes of the commission. But again, as I just mentioned, the decision on the law and the decision to adjudicate are two separate decisions. And so, no, the commission has no incentive to issue a final decision because it can get it effectively by writing these notices.
And where does the case stand now?
We filed a petition for a writ of certiorari to the Supreme Court. In other words, we've asked the Supreme Court to hear the case. We've obviously cited to Sackett and other cases like that. We found some cases in other circuits which are properly, we believe, apply a more pragmatic approach, which is what the Supreme Court has said. And we've asked the court to decide whether an agency can keep its decisions non-final simply by postponing or never deciding whether to adjudicate, whether to bring a lawsuit against Jake's, which is the position we're in. And I think the court will decide whether to take the case next month.
Oh, that's exciting. Wow. Best of luck. Gosh.
Thank you.
And if I read correctly, they've been at this for almost over 10 years now.
That's right. That's right. And again, no change in the commission's decisions, not even a hint that the commission is reconsidering any of its previous notices. And so we think it's ripe for review at this time. There's nothing else Jake's can do except get a court to look at it.
It seems like we're at a time right now in public policy where there has fortunately been more movement and more focus on kind of an out of control administrative and regulatory state. And there's attempts through policy to reform it, but there's been real movement in the courts. I mean, I think of Loper Bright decision that we've covered on this podcast a number of times. What do you see as like the future? I mean, what do you think that we're in a moment where some right sizing can happen?
Yeah, I do. And you're right about the courts lately. This Supreme Court seems very interested in these kinds of issues. But Chief Justice Roberts also doesn't like to move too quickly. And so he's patient and waits for the right case, which can be frustrating for individual parties when they think they have a good case at the Supreme Court. But the lower courts have been better too. And as you mentioned with Loper Bright, now precluding courts from putting a thumb on the scales, we think that will help. And hopefully one side effect of this is that agencies will be a little more careful about what they choose to go after, knowing that the courts are going to look a little closer. But an important part of that, we think, are cases like this, in which the agencies are avoiding judicial review. And so we understand the concerns that the courts could get clogged with all these kinds of cases. Of course, we think there could be more courts. President Biden vetoed a bill at the end of his administration, which would have increased the number of courts. And so if the agencies continue to grow and continue to issue more and more regulations, then the courts have to be up to the task and keep them in line. And we have to hope that President Trump and Congress do some real reforms and prevent these kinds of things from happening. Agencies, again, they have the power to issue what are called notice and comment rules, and those are effectively have the force and effect of law. But they also issue, like in our case, notices. They issue documents called guidance. Sometimes you may remember President Obama issued the Dear Colleague letters to universities, which supposedly told universities how they were supposed to handle certain in-house adjudications. And none of these, again, are officially final decisions by the agencies, but they have all the force and effect of final decisions. And the courts need to look into these.
Yeah, well, I really appreciate the work that you're doing and your colleagues at the Pacific Legal Foundation. Like I said at the jump, I've seen your guys' work for years, and it pops up in so many areas defending businesses and hardworking people who kind of get caught up in government, like they become the target of government, or they're treated unjustly. And you've done a lot of great work on behalf of ordinary people, and I think that's super. That really deserves to be commended.
Thank you. It's we love our jobs. It really is. It's you think about it in law school, and I actually get to litigate constitutional cases. So we love it, and we certainly love it. It's very satisfying to represent these companies and individuals who really just want a shot to make a living. And in this case, for example, if we win, all we would get is a case in court, and we could lose that court. We could lose that case later. But all we're asking for here is just a chance to make the case to a court. So it seems like a simple ask. Shouldn't be too much to ask that the government prove its case in court.
Well, I applaud Jakes for standing up. It's not easy at all to stand up against a massive government agency. You feel like they have unlimited funds, unlimited time. They kind of do. And
not only
for all intents and purposes.
Yeah, and not only that, but they have to. Jakes will be regulated by the commission forever. So this is not a one. A party can apply for a permit to have a parade. That's a one-off situation. But in these cases, the companies are continually regulated. So it does take a lot of courage to stand up and stick their necks out.
Yeah, well, I mean, it's just another example of government really being a barrier for a family-owned business. And I mean, the crazy thing about this. Can I say the sizzle in this is that it's about, whether it makes a pop or a bang noise.
Yes.
Which, man, I understand maybe why they kind of got there, but man, it just seems crazy.
Yeah, no. And the original regulation may have made some sense, but the agency has admitted publicly again that the fireworks Jakes is selling are not subject to that regulation. And if they want them to, they should do so through the proper channels.
Well, Oliver, I greatly appreciate the work that you're doing, and I really appreciate, really want to commend Jakes for standing up. I know I hope that they are able to sell their $2 million worth of inventory sometime soon, and that, they can get clarity at least, but that, that we can kind of keep rolling back a lot of what I think is overreach by the administrative state and kind of push back on regulations and kind of a lack of due process for so many Americans. So thanks so much for what you're doing to fight that good fight. Yeah,
thank you. And thanks to AFP for all their work as well. And thanks for your time today. I appreciate it.
Sure. Well, thanks. Well, hey, folks, always remember that liberty and freedom are easily taken for granted. Don't take it for granted. Go out there and defend liberty and freedom. Thanks for joining us.
Thank you for listening to American Potential. You may listen to more stories from Americans working every day to expand freedom and opportunity in their communities by visiting AmericanPotential.com.